So, good morning, you all. One more webinar from Mehta and Mehta. And, this time we have taken up a very apt topic in a very good time, as Mr. Bhatia said. It's all AGM time. So, today we'll be deliberating on Secretary Standard 2, the AGM, EGMs, all those general meetings, and the court convening meeting. So we are privileged to have Mr. Bhatia. I think people from Delhi must be knowing him, and he is a very senior practicing company secretaries, and he has more than 3 decades of experience, out of which more than 25 years in this company secretary profession. And Mr. Bhatia, I know him when I was a president in 2015. He was one of our task force committee on a company law, because that time the Companies Act was just introduced, and we had many task force committee to give advice to the Ministry of Corporate Affairs. And I know him since then, and I can see his passion and kind of interest in the topic. And so about Mr. Bhatia, he's in practice for more than 25 years. So he's he has an all-round experience. Of course, company law which is a very core, but he has handled many work on those NBFC, RBI work, NCLT, merger and amalgamation work. He has also handled many, Mr. Bhatia has also handled those trademarks and joint ventures and all. And Mr. Bhatia, in last 2 years, he is with Secretarial Standard Board. So since we are discussing SS-2, of course, we have the best persons, to deliberate on this. Mr. Bhatia is a very silent worker, and he is a regular faculty in ICSI programs, and those, he also he's a faculty for those student programs and all those study circles and webinars and the seminars. So he is advising many good listed companies, and some of them, they are all very good branded companies. So thank you, Mr. Bhatia, being a part of this webinar. As we said, this probably we are doing it for almost 2 years, and the idea is to deliberate, on a current topic, and take out the detail of that, of those topics. So, and for this, we also have Mridul, who's our partners in Mehta and Mehta. Now, Mridul comes with almost 2 decades of experience, and she is also a specialist in data protections, and of course, she has handled everything. She also had the experience in heading the insolvency work also. So great to see you, Mridul. And then our veteran, Mr. Bala. Mr. Bala, again, he comes with almost 4 decades of experience. He's a prolific speaker, writer, and he's also very silent worker, for ICSI. I've seen him, in CCGRT, he has probably trained many youngsters. So many of those company secretary across country, they may be knowing him, and very passionate about the professions and the topic on a company's secretary. So I think some of you must have read his article also. So he's a very regular contributor of the articles. So thank you, Mr. Bala, again a part of Mehta. Again, always a privilege to listen to you, sir. So without taking much time, Mridul, you can share your screen. Okay, so I'll just stop this.
We'll ask you, Mr. Bhatia, to give a...
Yeah. So sorry. Yeah. Mr. Bhatia, can you just share your views probably for 2 minutes, then probably Mr. Bala, then, you can then ask Mridul to give up.
Thank you, Mr. Mehta. Thank you, Mr. Balaji, and thank you, Mridul. Welcome. Yeah. I welcome all the participants to this webinar. The topic is not new. Everybody is familiar about SS-2, but to my knowledge, this is one of the topics which is known but not read. That is the plight. That is the plight, because I am saying that I got many queries on this topic. Had the people are conversant with the SS-2 provisions, they would not have raised the queries. Anyhow, awareness of the SS1 and SS2 is very much necessary. My learned friend, Mr. Sudhakar, who I'm missing today, is very passionate about popularizing SS1 and SS2 all through his career now in the last 3-4 years. He was really working on the making this SS1, SS2 familiar to all and each everyone at student level, at company secretary level, at senior levels even. Many people who ask me questions rather on the court convened meetings and other things, rather all are answered in SS2, provided the thing is that we have to see the implementation. At times there are controversy. I agree. Well, as I told you that there is a court convened meeting and there is a difference between the SS2 and the court orders, then the court orders will prevail. We will come when the topic will come. Anyway, this is our latest SS2 version which is in existence from 1/4/24, and we must go through it, and the institute has given a guidance note on it also. I'll request everybody to have that guidance note and go through that, and then see what are the nitty-gritties of this SS2 and how to implement it. Now I'll request Mridulji, not taken much time because this presentation is very important. Let her take the
Mr. Bala, you can also introduce Akshar, yeah. So Akshar is a chartered accountant and company secretary. So probably anything, from the financial ledger or India's angle, probably Akshar will be there. Thank you, Akshar, being a part of it. Yeah, Mr. Bala.
Good morning to all of you. I have a great pleasure in welcoming you all for today's knowledge sharing seminar. As Mr. Bhatia pointed out, SS2 has been very recently revised, effective from 1st April 2020. The basic revision has come more of the, addressing and simplifying the practicability and also certain modification to the existing definition, fine tuning with the things, something like a record to cutoff date. Meeting can be held anywhere and everywhere with the consent of the shareholders, as against the meeting can only be held, AGM can be held only at the register office of the company. In case of the wholly owned subsidiary, which is established outside, even you can conduct the meeting outside, because these are all the amendments which have come in the MCA circular. And again, when we talk about the exemption, earlier people are all aware that the Section 8 companies were actually having a exemption SS2, but very recently, I think some years back, after the pandemic time, a circular has been issued by the ROC saying, the exemption will be available, provided they are actually compliant. They file the annual statements, annual return, etc., and other things and all. So what this SS2 has actually brought in, they have actually modified all these changes which have been there earlier, whatever is there, and subsequently whatever the notification has been issued by the MCA, they have actually fine-tuned. And as what you were telling about this AGM applicability, court convened meeting, etc., there are also issues like that, to what extent SS2 is required to be followed, what extent is there in the court direction different than SS2, what is to be done. All these aspects are very much discussed in the SS2. In my view, the extraordinary job has been done by the entire secretarial standard board of our institute. And coupled with that, the guidance note, which explains with the practical aspects, with the examples, etc., and other thing and all. As Bhatia says also, I'm also very sorry to note many of the youngsters, they don't go through the publication. So much efforts have been put in, but we don't look it through the instruction. If people actually take a time and read and understand the things and ensure the compliances, many things will not be coming on that. I've been seeing it left and right. ROC has been taking issues on various issues on SS2. Especially complying with the section 101 notice issued, who to receive, what is to receive, explanatory statement, and again proof of the notice to be provided. So all these things issues are there. When it comes to the compliance, it is basically a company secretaries in all the companies where the company secretaries are there. And in respect of those companies, especially I'm talking about the private companies, unlisted companies, where the company secretary is not required to be employed. So we think this only directors are responsible. According to me, it is not so. It is basically the practicing professionals who are actually advising to this company, who are actually associated with company, they are basically responsible. So in the light of that, this particular seminar Of course, very much important to get familiarized. In fact, Mridul has actually put up everything. What is Companies Act? What is the requirement by SS-2? What are the things? What are the finer points one has to take care of it? All those things. And I think it will be definitely going to be a very much knowledge adding section. And many people who are having a doubts, you can put it your doubts in the chat box and you can raise your queries. We will be taking up then and there and it will be answered. Because we have the expertise of Mr. Bhatia, who has over 3 decades of experience. He has been working with the listed companies. He has handled many practical situations. So he will share his practical experience, which will be great benefit to all our members. I'm also looking forward for more learning in today's session, actually. With that, I think I'll hand over the mic to Mridul. She will take up. And we will also allow you to speak, but your speaking will be allowed at the end of the presentation is over. You can raise the hand and we can discuss whenever you have some queries. Otherwise, you please put in the chat box. We will keep answering. Over to Mridul, please.
Thank you, Bala sir. So yes, and as you rightly said, I just want to reiterate, it's a learning for everybody today. So I'll quickly now start with the presentation. We have too much on the plate today. General meetings constitute a considerable part of the Companies Act. Today we are focusing on the secretarial standards. So secretarial standards, and as we call them as SS-2, issued by the Council of the Institute of Company Secretaries of India and also approved by the central government. We all know adherence to the standard is mandatory as per the Companies Act itself. The standard prescribes a set of principles for convening and conducting the general meetings and all related matters. I am highlighting this particular recent ROC order, and thank you, Bala sir, for sharing this with me and your contributions to Taxman. You are contributing your articles very frequently, which is of help to our fraternity. It highlights the importance of governance and complying with SS-2. So, dear friends, the penalty of 2 lakh for violation by PCS for not pointing out the non-adherence of secretarial standards in his secretarial audit report. This is in the matter of SR Shipping Limited, and the order is very recent, May 2023. Now, what is the purpose of a general meeting? A company is an artificial person. It cannot decide the matters itself. So these decisions, they have to be through resolutions passed by the members only. And how will the members act? Can the members act individually? No, it has to be as a collective body in a general meeting. And then the purpose also is to provide a reasonable and fair opportunity to all the participants in the meetings to take the decisions as per prescribed provisions or procedures only. To set the context, now what are the statutory provisions here which are relevant? The general meeting, section 96 to 122 of the Companies Act, read with the company's management and administration rules, and then SS-2, the revised SS-2, which has now been made effective. Before I go ahead, I don't know, but why we still use the nomenclature shareholders meetings? I fail to understand that. Nowhere in the statute, in any official publication, you'll find this word. The reference is always to the word members. Do we really understand the difference? A person might be holding the shares. He would be a transferor, or in case of a buyback, say the shares have been transferred to the escrow account. But until he is entered in the register of members, he is not called as a member and is not entitled to attend and vote at the meeting. So I always try not to use the word shareholders meetings. Now, what is the applicability of SS-2? SS-2 applies to all types of general meetings and to every company, including private and small companies. Even companies under the special acts. So I remember in 2010, I entered the insurance industry. I was with a very high, it's a highly governed group, the Max Financials. And at that time, 2010, I'm talking when I think the provisions of incorporating in articles were not that exhaustive as they are now. But since we were regulated by the IRD at that time, we had taken care that the the terms contained in our JV agreement with the foreign insurer, the investor, were there in the articles, and we were ensuring all compliances even if they were not mentioned in the Companies Act. Sectoral standards were of course not there. So even to the special acts, and if there is any inconsistency between SS2 and these special acts, then the provision of the special acts shall prevail. So SS2 does not substitute any existing law, rather it supplements it to promote better corporate governance. Please also take note of the exemptions. Many of you would be working in companies registered under Section 8 of the Act, or in private companies, some IFSC companies. You need to particularly jot down the provisions which are applicable to you under the Act, but not as per the secretarial standards. There are exemptions, there are MCA notifications. And now in the revised SS2, we also see that the exemption provided to a Section 8 company or a private company and government companies also, they will be applicable only if they have not committed any default in filing their financial statements or annual return with the ROC. So this is very important. Now, what are the various kinds of general meetings? AGM, EGM, meeting of class of members, of debenture holders, creditors, and finally the court convened meetings. We'll briefly look into the nature of each of these 5 categories of meetings. Annual general meeting, section 96. Now, again, every company other than one-person company should hold a meeting of its members called annual general meeting, and the word annual itself says each year. Calendar year, financial year, this annual, but it's a calendar year. And the nature of business is significant. It's either ordinary business, special business, 4 types of ordinary businesses. I'm not repeating. And then any other business other than these 4 is special business. So this is the time when the members get the opportunity to discuss the affairs of the company and exercise their control over the management of its affairs. EGM section 100. And it can be called as and when required or at the requisition of the members. The nature of business has to be urgent business, which may arise between 2 AGMs, and all the businesses special business. We have this special meeting. It is also in the nature of a general meeting, and all the provisions relating to general meetings apply to the meetings of a class of members, like, for example, the holders of preference shares of a company. These resolutions passed in such meetings only would bind the members of that particular class, like there could be a reason to vary the rights of such shareholders. And similarly for debenture holders, creditors, there could be some meetings which bind only this particular class of shareholder, debenture holders or creditors. All the provisions of general meetings apply to such meetings as well. Very important part of the meetings, the court convened meetings. And Bhatia sir, now, I look up to yesterday also, you shared so many, I was enlightened, so many instances, the practical scenario, how the courts are currently conducting the meetings. So I would like you to now please take charge here, at least.
Thank you, Mridul.
Yeah.
This is one of the questions which oftenly is asked to me by my fellow colleagues off and on. What is the norms for that? Now, the thing is that when the court convened meeting is necessary, mainly we call it for the mergers or for reconstruction, in companies matter, when we go to NCLT, they call the meetings of the creditors, they call the meetings of the shareholders or class of shareholders. Now, the thing is that what are the differences? Differences between SS2 and court convened meeting are mainly 3 ways. A, this meeting is convened by at the order of the NCLT, not by the board. NCLT directs to convene a meeting. Second, the NCLT itself appoints the chairman of the meeting. The board the chairman of the board or the appointment as per articles is not relevant there. Now, the third is that the appointment of scrutinizer. SS-2 says that the appointment of scrutinizer and agency is to be done by the board. Well, here the appointment of scrutinizer is by NCLT itself. Now, the only difference we can say is that today, while making an application for asking court to convene order meeting of the shareholders or creditors, we can request that the name of the chairman, we can request the name of the scrutinizer. Then that is the prerogative. That is the prerogative of the NCLT. They may agree, they may not agree to it. But normally they agree to it. That's another issue. But in the big companies' cases, they do not agree. They appoint their own persons from the panel as chairmen, vice chairmen. At times, scrutinizer is also from their own panel. Then that the persons are there. Now the major other difference is that when the meeting is held, then the chairman's signature is required on the minutes. Now, the chairman may not give us the minutes. At times, the chairman say, I have been appointed by the court. This meeting is a court convened meeting, and the minutes I will submit directly to the court in a sealed envelope. They, with an affidavit, they submit to the NCLT. Then, at times, we have to request to the NCLT to give us a copy, because in the second motion application, we have to write down that the meeting as per order was convened, and these are the resolutions which were passed by the creditors, oblique, shareholders, or anybody else. The code normally calls for the separate class of meetings. They do not allow to combine all meetings together. They ask you to, even preference shareholders are there, so that meeting is separate. This shareholders meeting, equity shareholders meeting is separate. In creditors, at times secured creditors meeting is separate. Unsecured class meeting is separate. These are class meetings ordered by the NCLT. But now the conduct of the meeting. Now the role of SS-2 comes when the meeting is ordered by NCLT. We have to convene the meeting as per SS-2 norms. That the notice, explanatory statement, dispatch, convening, holding, everything, then we have to follow SS-2. These are the major steps. Now, one more thing is that the newspaper advertisement, which we give in the case of general meeting in a English newspaper and the local language, vernacular language newspaper. Here also the role of NCLT comes into. NCLT directs that the notice be given in the specified newspapers. That is in English, say FE, in Hindi, Jansatta. They may say any other, Times of India or any other Hindi newspaper of the state. In Rajasthan, Patrika say in Rajasthan. So that is again their prerogative. We cannot go with our own wind and fancies. We have to comply with that. So these are the major differences. Now, one more thing which comes up, which is again a dicey question at the moment still, is that when we pass a special resolution or a resolution here, do we need to file it with the ROC? What is the status? Status is when we don't have the copy of minutes, how can we file it? We have not been provided by the copy of the minutes, how can we provide it? So normally, if the minutes are provided by chairman to the company for onward submission with the NCLT, then I suggest all my clients to file form with the ROC for the resolutions passed. Otherwise, we don't file it. And never questioned by ROCs in the past itself. This is my experience. Carry on, Rizal.
Yes.
You are rightly touched upon, Mr. Bhatia. Thank you very much. Very clarification. One thing which is coming out very, very clear, as he rightly said, chairman is appointed by the court. And again, the newspaper publication is actually directed as per the court. And of course, he touched upon the very, very important point of the minutes. That is where, the excellent coordination will be required between the company's side and also the court-appointed chairman in relation to the meeting. I think Mr. Atul has been actually handled many such issues in a listed companies where he was working with amalgamation, merger, NCLT order, etc. and all this thing. It is normally a joint meeting is actually taken and checked with them and tell them this is what the provision, this is what it is. We normally agree with the chairman that he will actually pass on the minutes copy to the company. That is what they normally done, but it is done actually with a joint meeting, etc. Otherwise, as Mr. Bhatia puts it, we'll have to apply to the NCLT to get a copy. So these are all certain practical aspects which he has very nicely brought out.
One more,
Yes, Mr. Bhatia.
one more I missed out is the quorum.
Yeah.
Quorum aspect, SS-2 versus the court convened meetings. In the court convened meetings, the quorum is fixed by the Honorable NCLT. Now, if the minimum quorum, they say that what should be the minimum quorum. We cannot go with the norms of 5 for every 1,000 and 15 for every above 5,000 and 5,000. No, they say this is the quorum for creditors meeting. They say this is the meeting for shareholders meeting, etc. But then they also say that what will be the minimum quorum. Oftenly in their orders, they write down that in case the quorum is not present in half an hour, then the members, creditors, etc. present, they will constitute the quorum, even if they are one only.
Yeah, this question will arise. Can they have a meeting with one person? Because
Right.
the NCLT order is very, very clear. I also seen this NCLT order because I also handle the case. They very categorically say within half an hour quorum is present, whosoever is present. That word whosoever is present, very important. Even one member
Very
is
important.
present, that is the
Even
quorum.
one member,
Yeah.
yes, even
Very
one
right.
member meeting. So to conclude, I can say that it's the directions that might be given by the court or the Honorable NCLT in such a scenario which would prevail. Though the meetings will be governed, conducted as per the secretarial standards SS-2, however, without prejudice to the directions and orders of the court. So someone has raised a question that can articles provide that an outsider who is not a chairman, director, member, chair, so chair the AGM, EGM sometimes. So in government companies, say one is that with this kind of information, one is that for private companies, you can have your own provisions in the articles; those would prevail. For government companies, you'll have to check if they are being covered in any kind of exemption category, and they can provide something in their articles which would prevail over the SS-2, right? So otherwise, the provisions for appointment of election of chairman are very clear. So here I would like to also highlight in court convened meetings the practicality aspect. Yeah, so other than AGM, any other EGM, the courts would look at the aspect of impracticability to call a meeting. Now, the practicability, impracticability is not defined in the Act. But how it is construed is that when it is impossible to convene the meeting for reasons which are beyond the control of management. Two precedents I have highlighted that the requisitionists, though they have the opportunity to approach the tribunal when the meeting has become impracticable, but they cannot approach the tribunal directly if they have not first exhausted the remedy of applying for an EGM themselves. And then in a scheme of amalgamation, a meeting was being conducted and the notice of the meeting, which was being held under the directions of the court, could not be delivered to the members owing to postal delay or some omission on the part of postal authorities that would not invalidate the meeting. So I think we have had sufficient discussion about the practical aspects. Thank you, Bhatia sir.
And to be very frank with you, Birdul, to be very frank with you, the question where they raised that regarding the article, etc. See, let us look at the practical aspects of it, because you also will agree, Mr. Bhatia also will agree. What happened in case of the listed companies? Question does not happen. Because listed companies, they are not only governed by the Companies Act, they are also governed by the LODR regulations, things of that. The question will come only in respect of the unlisted public companies and also the private companies. Now, law permits the private companies, unlisted companies, they can actually have the stringent directives, stringent conditions in their article built in, which will actually prevail. That is there. But in practice, most of the annual general meeting in the private companies, even the unlisted public companies, do the directors actually present? What is the practical? Because many people are here, as much as about 170 people are there. Many people will be having their experience. They can actually think over, they need not give the answer. Because my experience also there, handling the unlisted public companies and the private companies, none of the directors in practice, they attend for the annual general meeting. It is only the members who are present, and what they do, they actually select somebody as a chairman. Invariably, company secretary is actually present, or the meeting is actually conducted, appointed a chairman from the members, etc. That is what it normally happens here. So there is no contradiction and other thing as well. This thing. So long as if the people are available, if it is there, if you are following it, it's fine. If it is not the case, this is that. Yeah. What you wanted to say something? More to
Hello?
yeah.
Yeah,
You
I
want to-
agree with you that in most of the unlisted companies, closely held companies, our own professionals, they do not know how to go about that. And invariably, I have seen in minutes while scrutinizing or in operation and mismanagement dispute cases, I have seen that in the minutes, they have said that so and so appointed as the chairman of the meeting, but they have not referred that whether he was a chairman of the board who took over chair or he has been appointed as per article. When the chairman is not present, that the directors sitting there themselves appointed it as per provisions of the article. These things are missing in the minutes. They do not incorporate, even they do not write down how the chairman is appointed, which is very important. Where there is no valid chairman, how can a valid meeting be there?
So the person who has raised this query is specifically mentioning the government companies. So in case of government companies, I would agree what you are saying. The respective minister chairs the meeting. So as I said earlier, the articles would prevail.
In the
And,
government companies, Mridulji,
also
the things are that everything is controlled by government. Anything, everything, whether there is in the article or not, if the government issues a notification, then you have to comply with that.
Yes, notifications.
you know to go
And
by
there
the
are special acts. There are special acts. Some government companies are regulated by those special acts. Again, SS-2 or anything, their own notifications and the provisions would prevail.
Will
So,
prevail.
yeah, in this case, even there would be authority under such a notification or a government undertaking that the minister can chair the meeting. So please check that in your case.
In fact, there is somebody write the questions relating to appointment, etc. and all those things. I don't think that is relevant here. But only one thing he has actually raised the question is whether the statutory auditor term can be only 5 years or less than that. That question he has asked actually. But really speaking, statutory auditor, when we talk about it, the law uses the wording 2 terms, not exceeding 5 years. That means the auditors can be appointed even for 3 years, 4 years, but that will be considered as 1 term. Okay, so maximum term is only 5 years. So when you talk about the term, if it is 2 terms, whatever the year the company is appointed, that will consider 2 terms. I think rest of the question we will not answer here because these are all we are talking about independent director, MD, WTD, that is not relevant there. Yeah.
And Bala sir, we are covering them in the next webinar now. So please attend. The next will cover your auditors, and then after that, the appointment of all the directors, everything will be covered, and then you can raise these questions.
Yeah, that's right.
Yeah, let's focus on SS-2. We have much to cover. So we start, what is the first step? Now, the first step is to convene a general meeting. And how can you convene it? With the authority of the board. Otherwise, the meeting is not valid. It has to be by the board or the authority of the board. The board must be duly constituted. Otherwise, the meeting will be irregular and resolutions will be invalid. Now, there is a food for thought. Can a resolution by circulation be passed? So I'm not answering. Please think about it. Whether a resolution by circulation by the board can convene a general meeting. Then the next.
Well, there is no prohibition as such in my opinion because section 179 does not prohibit that these are the items to be taken at a board meeting only. But as a protocol, since it is a very important matter, it should be taken up at a board meeting only. But there is no bar that it cannot be taken by circulation.
I agree. Then the issuance of notice has to be given to every person entitled to notice. Oral intimation, is it allowed? No. Who are the persons entitled to notice? Every member of the company. Now, the member, not only the equity shareholders, but also the holders of preference shares.
Mridul,
Even
here you have brought up the very, very finer issue in your earlier slide. You have explained very nicely shareholder and the members. By merely holding the shareholder, he does not become a member. Member means his name is actually entered in the register of the members. That means after acquiring the share, if the AGM is coming in between, if his name is not entered in the members register, he will not be entitled to get the notice. Yeah. You brought out this very finer point in the very first slide only. Yeah.
There is one exception to this, sir.
Yeah.
In the case of a death of a member, it's legal heirs. Even if their name is not member, they become entitled.
Yeah, that is right. I agree with you.
Yeah, so that is so legal representative of deceased.
Yeah, I agree with you.
Right, right.
The auditors, the secretarial auditor, cost auditor, the debenture trustees, all these people. And there are other recipients. Now, depending upon your category of company, it could be, in case of listed, the stock exchanges, financial institutions, if you have an agreement with them, your foreign collaborators, the holders of your stock options, any other recipient with whom you have agreed to give the notice of general meetings. And in case of court convened meetings, the court appointed chairman and observers, as we just discussed. And in case of a private company, there could be additional provisions in their articles. Now, addressing of the notice is very important. To which address it has to be. For each category, you have to be conscious of the fact that the addresses are duly registered, updated with the company or with the depository, as the case may be. In case of a joint holder, person's name appearing first, and the opportunity for at least once in a year for updating the email addresses is very important. If the member does not update, then it's not considered as the company being in default for non-receipt of a notice. The notice to representatives and assignees is very important. So as Bhatia ji, you rightly pointed out, this is a distinct case, so here also we have a slide on it, because in case of the death of a member, how will you deal with the situation if singly, jointly? So then the nominees take the forefront and the first surviving joint holder, or if all of them, so yeah. And in the absence of nominee, the legal representative of the deceased member. Insolvency, the assignee, and in case of winding up cases, to the liquidator. The mode of issuing notice is also important. Now, there are various modes. You have a lot of flexibility, whether by hand, ordinary post, speed post, registered post, courier, emails, electronic means are now the popular ones. Again, subject to a specific mode which is prescribed in your articles, or any specific government with a JD partner or investor, then you have to comply with that mode. A person sitting in some foreign territory, they might have their own requirements. I have faced that situation. We comply with that. And so specific mode is important, which you need to adhere to. Now, in certain cases like e-voting facility or postal ballot, when there is there, or when a meeting is called by the requisitionist, so then the ordinary post is not allowed. In case of emails, you have to be mindful that the attachment of the notice is in a PDF format or a non-editable format, and the URL links and addresses of the websites are properly informed. How many of us are maintaining the proof of sending of notice, and how many of us are struggling with it? So Bhatia ji, in your case, yesterday we were discussing, you are handling so many listed entities. I would not like to even talk about the private, closely held companies, how they are doing it. But what is your experience in case of listed entities about this, maintaining the proof of sending of notices? Is it being maintained? How is it being maintained? Are there any gaps?
Thank you, Mehta. These days, normally we are sending the notices of all listed companies through government agencies, either NSDL or CDSL. We take the services of these two government agencies, the list of all members who has given their email IDs and registered either with the company or the registrar or the depository, which is in the records of the company. We take out that register and then dispatch it en masse to all the shareholders through email via NSDL, and then keep a record and simultaneously, as per listing and LODR requirement, send a copy to the stock exchange for their records as per LODR norms. So that is the again. Then this is the conclusive evidence that the notice has been dispatched to all.
So, proof of sending has to be preserved by the company. There is no specific period also, unlike for most of the cases when you say 8 years. In this case, no, it could be for indefinite period of time as it might suit you, or as may be decided by the board. In case of legal proceedings, of course, you need to maintain it as a crucial evidence. So this is a very important piece, but I have seen lapses. Let's not talk about it. There are lapses. There are challenges also. But guys, as compliance officer, it's our duty to overcome those challenges, to convince the management, the board of directors that it's important, it's in your interest. Then the contents of the notice. What all should a notice explicitly state? The date, time, day, date, and time, and the place. So day, date, and time, business hours, lot of flexibility. You can do it even on a AGM, even on a public holiday or on a Sunday. The only condition being it should not be a national holiday. So specific time has to be mentioned. Now here it is important that the meeting, for example, might start at say 4 p.m. or even 5 p.m. So do you need to conclude it by 6 p.m.? No. You can, the meeting can continue even after the prescribed business hours, but it has to start before 6 p.m. Now regarding venue. So again, you see, gone are the days that only at the registered office or at some other place within the city town.
1 minute, 1 minute, See, Mr. Bhatia, see, you have so many foreign subsidiaries or foreign companies, in India, and you wanted to have an alignment, with them, because somewhere it's an evening or it's a morning here, and there they have a night. So it is very likely that somehow you have not been able to even start meeting at 6 p.m. So so for all purpose, as per the standards, you have to start the meeting before the 6 p.m. right?
Very right, sir. Sir, we are adhering to these norms only. We have been telling to all our concerned identities that we are duty bound as per SS and the law. We have to hold the meeting between the business hours only. So they have to manage their times there only, because they cry also at times, but we can't help it out. We normally do it between the business hours and never do go away from this rule.
So they have to follow the Indian the times, right?
We are there to Indian times, IST.
IST.
We have in Japan, we have in Italy, we have in I have in Ireland, I have in Norway. Different timing zones are there, but then we request them to be comfortable with us as per our Indian norms. You have to abide by this.
Absolutely right, actually, Atul, because when we are incorporated the company under the Indian Act, we will have to follow the Indian law. They will have to get adjusted to their whatever it is, although it may be inconvenience to them. I also face this sort of a situation. They are telling odd hours, you are telling according to. I told him, sorry, sir, it is actually IST. The timing is as per IST.
Because see, if you start
in recent past, in one of my company in Armenia, the chairman was in Armenia. He said that it is too much snowfall is there. I'm not in a position to reach my office and all my electronic instruments to join this meeting. He called up, can I join from the audio mode through my this mobile phone? So this was a very difficult question. Can I allow him to through video? If video is not available, can he be available through audio? Then the recording of audio was arranged and we allowed him, because the permission is through audio video means. So we allowed him, and then the recording delayed the meeting by 10 minutes, arranged the recording of the proceedings.
Okay. No, so I was just saying, suppose if you wanted to start a meeting, say at now 11:45 a.m. in Toronto, it is 2 in the morning, 2:15 in the
In the
morning.
morning, right, right.
So surely, probably, they may not like to have at this
But in
time.
JV companies, so these things do happen normally. In JV companies, in all the countries, wherever the time zone difference is more than 4 or 5 hours, this difference is there. Italians are too adamant. They say, we won't attend, we want our timings. One thing I felt very difficult with the Italians.
So, what is a practical way of doing it? Suppose, you don't have a choice. And then one is, you just say, look, there is no the quorum and the meeting is postponed for another 3 hours or 4 hours just to match their time.
So at times we have done it, sir, that the meeting was called and convened within the time and then adjourned for 5 hours on some pretext and then again held.
Okay. And which is a proper convened meeting, right?
Proper convened meeting.
Yeah, that is proper convened. That can be done. That
So
can be
that's
done.
That mode we are doing it. That we are doing it, adopting this way that we call the meeting within the business hours in India as per IST, then adjourn it, then reconvene it as per their convenience.
That is where your expertise is required, Atul.
That's what,
I say today a company secretary bana.
Right, sir. These are all experience. It comes with an experience.
Yeah.
So Mr. Bhatia will agree, the Armenian company, some Toronto company,
Yeah.
So, yeah, Mridul. Yeah, continue.
Yes. And then I was talking about the venue of the meeting. Again, a lot of flexibility. Now we see meetings can also be held in case of wholly owned subsidiaries or IFSC companies outside India. Now it's being allowed. And AGM of a government company, again, a lot of flexibility, unlisted companies. So whatever is applicable to you.
Mr. Bhatia, now you are allowing a company to hold their shareholders meeting outside India. So maybe
consent is required. Then the consent is required 100%.
Okay, right.
Only then it is possible, no, sir?
Right. So then it means again those timings will be what? Their mornings or our mornings?
No. Even if the meeting is abroad, timing we do as per IST only.
IST only. Okay.
You cannot leave that norm. That is a separate one. Place of meeting is a separate norm. Timing is a date, time is a separate norm. So we have to adhere both.
I think somewhere you should take it up at the Secretary Standard Board. Suppose if you are allowing 100%, so it means somewhere your shareholders are living outside the countries. That's what for their convenience. Now, if you say follow the Indian IST time.
And particularly with this VC meetings and joint ventures, many joint ventures are coming in. These things require amendment.
Atul bhai, you get up at 2 o'clock and you be present for the meeting and you say quorum is not there, I have adjourned the meeting. That's all. You suffer yourself. Don't make the other people to suffer.
Right.
So mostly in these JV entities, if they are private, if the JV partner, the company incorporated in India is a private company, or they can have their own terms in the articles and in their JV agreements and shareholders agreements, and they would prevail. So those solutions I have covered.
So Nupur, Mridul, see, you are talking about a normal situation. We come across why people come to as an expert because these are the problems, where there are fights, there are two groups. He said, look, we wanted this time, that time,
Yes. So depending upon the type of company and JVs and constitution and whatever exception, so there's some solutions can be arrived at. Otherwise, yes, it's a problem. Then the proxy. Proxy is important. I have covered this in detail in further slides. Then nature of business to be transacted, special business, ordinary business. In case of special business, it has to be in the form of a resolution accompanied by an explanatory statement covering all material facts. And ordinary business is resolutions are not required to be stated usually, except there's an exception. And then how we pass the ordinary resolutions and special resolutions.
Mridul, somebody is asking a question.
Yeah.
When the board is not in place, whether the annual general meeting can be convened by the shareholders themselves.
board is not in place. No, so we talked about convening of a meeting. No? Convening a meeting has to be convened with the authority of the board at the first place.
Mhm.
Board approval is must. So how can the shareholders themselves? The provision is only for the EGM, the requisitionists can request, but AGM, the board is not in place. How can that be possible? So there's a deadlock or something, we don't know, but board approval is must
Yeah.
for convening a meeting.
When the board is not in place, that
It's-
itself is a non-compliance first place. And
It's a non-compliance. Then there are separate provisions we'll discuss in our webinar covering the appointment of directors, that if only one director is there. So, quorum and all, a lot of things need to be checked. But no, there is no such provision. Shareholders cannot themselves convene AGM.
shareholder has got only the right, when the meeting is convened, if the directors are not present, they can actually conduct the meeting by selecting somebody among themselves as a chairman. That is the provision which is there.
Hmm.
In a listed company, do we need to send a physical copy of the annual report for such a member whose email ID is not registered, or only for those who was requested for it?
This is what usually happens. I have experience with my clients, and we try to address this issue where there are challenges. Bhatia sir, would you like to mention something, how you have solved this concern with your clients?
What we are doing is, as per MCA circular, we are sending through email only. But as per MCA circular, whosoever requests us, there we send it physical copy only on request, not to everyone.
Not to everyone. So this is generally what everybody else is doing as well. Physical copies now, these are being avoided.
What is the time limit to keep the recording of the board meeting or AGM?
I have covered this
Okay,
time
you're-
limits and
you're-
all.
acha, you're
So
discussing it.
let's
Okay.
move ahead.
Okay.
All these things, even the circulation part, now physical,
Okay,
we have
okay,
covered in
okay.
the slides ahead.
Okay.
So contents, then the explanatory statement, the matters to be contained therein. So again, if there is a reference to any document, contract or memorandum articles, then they should be available for inspection. That has to be mentioned. In case of appointment, reappointment, or fixation of
This is very
remuneration of
important. This
Hmm.
point is very important. I will request all my professional colleagues to note down this point, because invariably they do mistake while giving all these heads in while dealing with appointment, reappointment, and fixation of remuneration of directors. So this 5 number point which you have covered is very important.
Very important, and in fact, I could have shortened my slide, but then I thought, which point should I exclude? Not even one. This is very important because practically, I'll tell you, in my corporate exposure, I have seen 2 or 3 or 4 of these details would not be available. There would be
Right.
it would not be available. And as a company secretary, I'm asking, no, it's mandatory. I have to put up all these details in the table. However, when the response is not coming, what do you do? But then, yes, after the back and forth and everything, the conviction has to go. Each and every detail has to be there.
So normally, I request all my clients to give a head that the information required as per SS-2 is as under. Then we give headwise all these details. And
Even
in case of listed companies
okay.
with SS-2 Regulation 36, both we club together and give these information under each head. What is the qualification? What is the experience, terms, appointment, salary, etc. Everything.
Yeah. Yes. So this disclosure is very important. Then in case of independent directors, again, the justification for choosing the appointee, and in case he is being reappointed, so then the performance evaluation report or a summary. Thankfully, here a summary can be given because performance evaluation sometimes it could be very detailed. So even a summary is allowed. In private company, IFSC, they can have their own provisions. So now what is the notice period? Notice period here, so at least the 21 clear days. It's so much of a, I think, a term of a Bible for us company secretaries. 21 clear days, then 22 days more, and then 25 days. I mean, additional 2 days if by post or courier. But if email, you're sending it through electronic means, so then these days need not be counted. Full calendar day, no fractions are allowed. And the notice also has to be published in a newspaper. For a Section 8 company, this has to be a 14 clear days notice, and they can have different provisions in their articles. And there is a provision for the special notice, we all know, where it has to be sent 7 days before the meeting. And then what is the shorter notice period? So shorter notice period, the consent norms have been changed under the revised SS-2. Earlier, the requisite consent was only for the 95% of members entitled to vote. Now there are some additional categories, additional clarification is there, added to SS-2 as per the Companies Act 2013. Entitled to vote is very important. It is irrespective of the shareholding of these members. So shorter notice period, again, you might be facing some challenges in obtaining these consents, or if you need to convene a meeting in a day's time. So Bala sir, we discussed this yesterday. We deliberated a lot. And thank you for enhancing my knowledge that because I have faced it. I have convened an EGM in a day's time at a shorter notice period. And so obtaining consents and enabling proxies, all of that has to be taken care of. And the consent has to be received prior to the date fixed for the meeting. I have also highlighted this term accidental omission. What is accidental omission? Is it defined? So accidental omission, we can look at various case laws, Bhatia ji, you would have come across in your court practice. Some of them I have highlighted. The omission which is neither design nor deliberate and implies absence of intention. There shouldn't be any malified intention or negligence. And then what is non-accidental omission? An error as to a legal position. So I have given an example of there's a case law here. So if there is a lack of understanding, the directors erroneously believe something to be true, because of which they feel that the notice need not be sent to a particular shareholder. So that is wrong in law, and that will not be considered as an accidental omission. Are amendments to notice allowed? So we see corrigendums very commonly in newspapers after the issuance of main notice. So yes, they are allowed, though the general rule is that only those items which have been covered in the notice issued to the members and those which are specifically permitted under the Act, they are supposed to be transacted at the general meetings. However, an amendment to the notice, including addition of an item, can be made provided the notice is given at least 21 clear days before the meeting, or of course complying with the shorter notice provisions. Any typographical or grammatical clerical errors. So in such cases, there are instances of erratum being issued, circulated at the meeting itself. So rectifications can be made. However, if the errors are in the text of the resolutions, so they are differentiated, but no correction should be made to the text of the resolution after the voting has commenced. Of course.
So, Mr. Bhatia, have you come across with any notice, like, any listed companies notice where something, by mistake, they've omitted, and then probably practically, you've done something to.
There are, yesterday also I discussed with Mridulji on this topic. The thing is that off and on, variably, I have seen various advertisement in the Financial Express Economic Time regarding these things, that these errors or something there. But as far as my knowledge goes, the law does not permit at all. And I do not allow any of my client companies to do any change in the notice subsequent to the issue, whether in the resolution. Normally, the meetings are called through VC only. In VC, so there is no scope. In the physically called meetings, we write to pass a resolution with or without modifications. But in the electronic meetings, this scope is also not there. There is no modification allowed subsequent to the issue of the notice. No change, nothing doing. Strictly no.
Okay. So, see, sometimes I've seen in some companies where those justifications, when you are taking any special resolution at the shareholders meeting, those justifications, sometimes the numbers are, mistaken, or probably the numbers are not correct, and so this can be rectified at the time of the meeting only. Look, this was the mistake, and we should be read like this, something like this, because I've seen in couple of meetings.
That is what I'm requesting you, sir, that I have seen ads in the newspapers. People, certain companies have done it in the past that this should be read like this should be read like that only. But no, I don't allow anything. I only go with the resolution like that only, and subsequently and pass another resolution with a postal ballot to ratify that resolution. Ratification through a subsequent resolution of the shareholders at a properly convened EGM or through postal ballot.
Right. Mr. Bala, any view, your views? You understand, like, when you give a notice in those justifications, where you give a details about that resolution, special resolution particularly, where those, sometimes the numbers are differing or probably by mistake, So can you take up at the shareholders meeting and say, look, this number should be read as this?
You see, there is a law also says any accidental omission, not materially affecting the things only can be done. So as you rightly puts it, the verb, if I understand, if there by mistake it has happened, or by omission it has happened, those things can be done. But any material changes which is affecting, that cannot be done as Bhatia puts it. By and large, in listed companies, it can never happen actually. I have hardly come across any of the listed companies. But of course, one of the corrigendum I have seen in case of the public announcement company where I was actually working, because they made some small mistake while talking about the manager to the offer or something like that. They made a small mistake. It was something like a DSPML or something like that. They spelled out DMPSL or something like that. They issued the corrigendum to that, saying that it should be read like that. It's a error. So that sort of the things only I have seen it.
Okay. So now there is Lokesh, asking, Lokesh Gandhi says whether the addendum can be added in the notice.
Addendum for what?
Addendum means what?
So sometimes, you have seen those, see, when you do a printing, that time you realize, oh, this page is missed out, or, so somewhere you try to put that, additional page in that, notice and all.
I was trying to say this, that see, whatever all these provisions are there, I just read out, but this does not reflect nicely at all, neither on the company's management. See, ultimately, who is preparing all these documents? Take onus, the company secretary, either you or your reporting manager. The poor chap, he would have entrusted you with the responsibility. Bhai, theek se pad lena, एक line check karo, no error should be there. Or it could be an external agency. So even if an external agency has been onboarded for reviewing all these documents, whose responsibility, whose head? It's the company secretary, the HOD, and his entire team take the onus. Does it reflect nicely upon you? And would you like your management chairman or even the company secretary reading out in front of an so-called atom, ye galti ho gaya, ye reh gaya. Now an addendum is being issued. These are not good practices, as Bala sir also mentioned. We should refrain, we should take responsibility, and there should be zero tolerance for any mistake or errors or missing out anything. Let's take onus here.
Mr. Atul, let me ask you one question. Because you are actually in the practice for such a long time, your firm is there, you have been assisting many company sector. When you take any particular assignment, are you not working with a proper checklist? Are you not working maker checker policy? Are you not ensuring each and every item is actually checked? When we are the professional, either in the employment or in the practice, are we not supposed to take care of all the things rather than committing to this? Even in the private companies, I know many of you will be knowing the past also, I discussed that There is a Madras fertilizer case. The RD has issued the very beautiful speaking order. There he spells out, one, the company appointed the company secretary. He is the sole person who is responsible to take care of the compliances. Directors are there only to run their businesses. So any action in related to the compliance, it is only the company and company secretary is responsible. Because certain issue, the ROC has passed the order penalizing the director and the company. He set aside the entire order in case of the Madras Fertilizer Company. He directed the ROC to initiate action only against the company secretary as a compliance officer. That is the extent. In fact, Mirdula has actually put up the point in the beginning of the slide only. In his SR Shipping Limited, the practicing company secretary has been actually penalized to the tune of 2 lakh rupees because he has not pointed out the non-compliances arising out of the adherence of the secretarial standard. This is the view when the regulators are taking it. Are we not supposed to take entire compliances in total and work with that? That is the first question which arises in my mind. Okay, something can happen. We are all human. Human error can be corrected. That is what the law provides. But when you say we missed out this totally, these pages are out, addendum to be added and all the things, are these things are all talking good about us?
Yeah, Mr. Bala, I know that's what many of the companies, they get those AGM notice waited, from us also in many cases, those large listed companies, because, they do not want to take a even single chance. Yeah, Mr. Bhatia.
One thing more I would like to add here that it is very critical in case of listed companies because any change in the contents of the notice may be material and call for the SEBI intervention. We have to see the materiality of the thing, then the disclosure norms, then the board, then the committee. Many things will be involved there. It is not that easy task to change the contents or any information there because this may come as a UPSI or you have to do STD entries or anything else like that. So we have to see many things before we think of this thing. So as a strict no, I am adhering to this policy that whatever error is, you go with that and subsequently pass another resolution through process. SEBI is very strict on all these matters. If anything goes little wrong, very difficult to handle all that situation. UPSI, unfair trade practices, disclosure norms, materiality norms, many things comes into existence.
Yes. So I covered this in the modification of resolutions part also in the slide.
Right.
And someone is raising a question about, if the accounts are not ready on the date of AGM, can you still conduct AGM? We have covered this ahead. Let's discuss it.
Yeah, let us wait. These things will come. That is why I'm not taking these questions.
Yeah.
Because you are going to discuss this. Yeah.
So here is a list of the accompanying documents. Explanatory statement, proxy form, attendance list, shorter notice consent forms, and all other supporting documents, financial statements, articles, and other documents.
Marduk, somebody has put addenda means a new item. No new item can be added. Very clear. Because once the agenda is released, only the item which are released for the agenda only can be conducted. You cannot bring out any new item. Yeah.
New item of provision I have covered now this point.
Yeah.
That again you will then tabhi ho sakta hai if you again give a notice of amendment.
Fresh
21 fresh notice.
Yeah.
Yeah, shorter notice that you can do, otherwise not.
Correct.
It's not suggested.
Yeah. Anyway, let us wait for that slide. Yeah.
Notes to the notice. Notes are an integral part of the notice and a lot of information. You can see this PPT later. A lot of, I'm not reading out everything, but none of this information can be missed. All this information has to form part of the notes to the notice. Can you postpone a general meeting once called? Again, the same thing, the same principles apply, that we should not resort to so much of effort, the shareholder, the members, and all of that. And why? What's the reason for postponing it? Unless it is beyond the control of the board, then the board will have to reconvene the meeting. And for that, a 3 days intimation at least has to be given to the members, and it has to also be published in 2 newspapers, the vernacular and English language. Now, if we talk about the frequency of meetings, the annual general meeting, as the word annual itself says, once in each calendar year. We are all abreast of the timelines. The first AGM within 9 months and subsequent AGM within 6 months of the close of the financial year, interval of not more than 15 months between two successors. The provisions relating to extension, seeking extension in time for conducting convening an AGM. You have to convince the registrar of companies for a special reason why you want to seek extension. Now, what is that special reason? Now, one of you were asking for delay, the financial statements are not ready. See, I have covered because we face it day in, day out. This is the most common problem. And as you rightly say, that private companies mostly face this challenge. There is a delay. Maybe in the financial statements are not ready. There is a delay in completion of audit. But then, dear, the solution is provided in the act itself. Then you can adjourn the meeting when your financial statements would be ready. But the ROC is not going to consider this as a special reason. And if all the private companies say so, then what is the status we are trying to achieve? So then the norms are challenged, and there is a general non-compliance which would be encouraged in such a scenario. You agree? And similarly, if you say that the company is not functioning or the management of the company has been taken over, this is also no excuse. A special reason has to be a very special reason. Like I have seen a special reason I have personally witnessed in 2 instances was of a restructuring during pandemic, and before that also a very special case of structuring going on, which was acceded to by the registrar of companies after detailed justifications provided by us. In case of EGM, anytime the only condition is the matter has to be urgent one. So otherwise the choice also is that you can pass the resolution through postal ballot. How EGM can be called? It can be called by the board on its own motion or at the requisition by the members as per section 100. The requisitionists themselves can call an extraordinary general meeting, and as we discussed, that a court convened EGM can also be directed. So there is this threshold requirement, I'm not reading, 1/10 and for the requisitionists. There are some timelines also in case of EGM by requisition. The board should proceed to call a meeting within 21 days of receipt of requisition and on a day which is not later than 45 days. And by requisitionists themselves, the meeting can be called within 3 months if the board fails to do so. The requisition will be signed by the requisitionists, and very importantly, the matters to be considered, proposed to be considered, will be set out. The quorum requirements, except in case of court convened meetings, but the quorum has to be as per these thresholds. In case of public company and private company, 1-person meeting, there is a plethora of judgments here. 1-person meetings are not allowed in any scenario. Quorum has to be personally present, and articles can provide for a higher quorum. Proxies are never included for determining the quorum. However, representatives of body corporates or president and governors of state, they are counted. So there are certain exceptions to this, whether a single member can constitute a quorum. The court convened meetings we have already discussed, and if the single person is holding the shares of all the shares of that particular class.
Mridul,
Yes.
suppose a person is holding a proxy for the 5 different entities who are holding the shares. Then there's a quorum requirement. Whether that can constitute the quorum.
Proxies are excluded now. These proxies are excluded.
No, the person who's actually represented for the entity. the entity is holding a share, their representative
Body
has been,
corporate.
the representative has been appointed.
So
A
representative of,
individual person. That's
Ah.
representative is holding 5 different entities. 5 different entities appointed one single person.
Yeah, so in the slides ahead on proxies, when we will look at the criteria of that 50% hold, I mean 50 persons threshold and the shareholding, how much. So there are a lot of scenarios.
Okay, okay. You're going to discuss. Okay,
There could be, so there are a lot of permutations, combinations here.
okay.
You know, that how much, even if the number 5 that you have mentioned, but if because the another requirement is of holding a particular up till a limit of share capital also, na? So
Okay.
that should not be violated. We need to check all of that, and this happens generally when you determine the quorum.
Yeah.
In case of postal ballot, the presence of quorum does not apply, obviously. Now, this is very important again, that who all should be present in your general meetings. And Bala sir, you were mentioning earlier that only the members come. One of the members is elected as chairman also. Directors rarely attend the general meetings, but the sectoral standards require all directors, they are expected to attend, especially the chairman of the audit committee, NRC, SRC. They are specifically required to attend the general meetings, and the impression is that that the chairman of the audit committee should attend the AGM. It's mandatory, but no, the standards require these chairmen to attend all general meetings.
Mridul,
Yeah.
I have actually seen practically in an unlisted public company, none of the directors were actually present, and meeting has been conducted by electing one of the member as a chairman. They conduct the meeting. But that company had an audit committee meeting. The ROC has actually issued a letter to the chairman of the audit committee and also to the other directors and also to the company. His non-presence of the audit committee chairman was actually the violation, and action has been initiated. The company has to actually pay a severe penalty for that non-compliance. It is there.
Yeah.
But by and large, yes, many of the private companies, unlisted company directors do not have. That is the practical scenario. Atul will know better, or even Bhatia can add on that. Real scenario is something, but when it comes to the complaint, when ROC initiate the action, is all the things, consequences are going to be severe. In fact, whichever the company I have been working with, in spite of private company and the unlisted public company, I also asked only one question. Are you concerned about the compliance? Are you concerned about the cost? If you are concerned about the compliance, don't bother about the cost, please come. If you are concerned about the cost, okay, all right, then compliance goes in havoc, but you face the consequences.
Similarly, yes, Bhatia.
Nani, I think I agree with you, Mr. Bala. The non-compliance cost is very high nowadays. But what is happening, sometimes I've seen those young company secretaries, they do some mistakes, and of course, all this, what we are discussing, it comes with an experience, So
No, Atul, I have seen in some of the places, the company people, secretary, especially the practicing people, okay, notice aa jayega to dekh lega, let us go ahead. This sort of the approach is there. Notice aa gaya to dekh lega kya hai? You are knowing it, you are doing a non-compliance. How can you allow the non-compliance happen, you being a professional? That is my first question.
Yeah, Mridul, you continue. We'll have to finish, as early as possible. Yeah.
And similarly, the auditor's presence. So statutory auditor has to be mandatorily there unless exempted. But he can also authorize his authorized representative. And secretarial auditor for AGM must attend unless exempted. But in case of other general meetings, it's the prerogative of the chairman to invite the secretarial auditor. Otherwise, the notice can be served for his information only.
But the statutory auditor notice should be given for all meetings.
Yes. So even for secretarial auditor, notice has to be given for all meetings. Even in case of other than AGM, for information purposes, he or she might not be invited to attend the meeting though.
Yeah.
Then the chairman, election of chairman. So again, there is a very well established procedure that the chairman of the board should preside over the general meeting, and if not there or not present within 15 minutes, then the directors present will elect one among themselves, and if that is also not there, then the members present will elect on a show of hands. Poll can be demanded, which has to be taken forthwith for election of the chairman. The chairman's duty is to preserve order of the meeting and ensure that the proceedings are conducted smoothly and the voting happens. Assistance of company secretary or any other director can be taken. Now here, so Bala sir, this proxies, lot of permutations, combinations, because when you say that proxy can act on behalf of members not up to 50 only, and holding in the aggregate not more than 10% of the total share capital carrying voting rights. So the instance that you were giving, we need to actually take a pen and paper and do the calculation. How many shares are being held by that particular authorized representative? Authorized representative is allowed to, is counted as a quorum, even if it's a proxy. But then these two criteria cannot be breached. That's the idea. And a proxy can be individual only, though it can be appointed by both natural and artificial persons like body corporates. And proxy can only vote on a poll. Private companies can have their own articles in this regard. But yes, very importantly, in case of Section 8 companies, only a member can be appointed as proxy. Otherwise, a proxy need not be a member. Form of proxy, Form MGT 11. Now we can go on and on here on the instances of when a proxy will not be considered as valid. It has to be duly signed, named, dated, and stamped. Stamping is very important. The provision of stamping is applicable as on date. Now, how you are fixing the revenue stamp, of what value, whether you are cancelling it. And if my proxy happens to be at a place situated in a foreign land, I have faced that situation. What is the stamp value of that particular foreign country? And then you also need to ensure the provisions of the Stamp Act, that when a document for a foreign country is entering the territory of India, so all those things within 3 months. So there are those conditions to be checked as well. And in case of blank and incomplete proxies, the chairman has the final authority to decide on the validity. The proxy has to be deposited within 48 hours, a longer period, even if it is prescribed in the articles, but it will have effect only as if a period of 48 hours has been specified. This timeline is very strict. And then the revocation of proxy is important. Proxy can revoke either by implication or by express revocation by giving a notice to the company, but before the commencement of the meeting.
If the multiple proxies are issued,
so then if you the proxy which is received the last one, the latest one is considered. That's the rule I would have mentioned somewhere.
okay.
Yes, the proxy which is dated last shall be considered valid.
No, received last or dated last?
Dated last. So yes, again, now this could be an anomaly if there is a delay in postal service or some other reason. But with the act says which is dated last.
Okay.
Yeah. So this happens. Even Bhatia ji, you would agree that especially
As
the
SS2 also it is dated last.
Yeah, dated last only.
Dated
right
last.
position. Dated last is the correct one.
We look at the date only, and that's why if the proxy is undated, it is considered as invalid. That these two provisions have to be read together.
Yeah, SS2 is very clear. Invalid situation, it is very clearly mentioned.
Yes, Yeah, very clearly. Undated proxy bilkul nahi chalega. In other cases, like if there is some other blank or something, so then yes, I mean it's allowed. The prerogative of the chairman, let's allow. The voting should take place. And then how? Now we come to the voting part. The actual when a motion proposed takes the effect of a resolution and the decision is ultimately taken. So the show of hands, ballot process, e-voting, voting by postal ballot, these are the various ways in which the decisions are taken. The conventional practice is that one member has to propose and the other member has to second, which is of course not applicable in case of e-voting nowadays. E-voting facility, I have covered the procedure ahead. The specified entities listed and those having more than 1,000 members, they are supposed to do it mandatorily. Others can opt for it. And also these entities will have to put the resolution to vote through the ballot process at the meeting. And same electronic voting systems, there's a flexibility, can be used both for your e-voting and for your ballot process. Initially, the resolution will be put to vote on a show of hands, and provided that it is not put for remote e-voting and a poll is not demanded. And the proxy cannot vote on show of hands. And then if a poll has been demanded, then the poll will be taken. And for that also there are thresholds for company having share capital other companies. And poll, if demanded, will be taken up at the meeting through a ballot process. Then what are the voting rights? Those members who are entitled to vote. Now there are different categories. Like I have put up all these categories under the heads of equity shareholders, only those whose name appears on the register of members. And in case of e-voting, there is a cutoff date. Only if their names are there on the cutoff date, which is not earlier than 7 days before the date of the meeting. In case of preference shareholder, joint holders, persons of unsound mind, minors, HUFs, you have to be very careful. So in-house departments, when clients come to us for consulting, it's very important to do this homework before your meeting, that who all are the category of shareholders who would constitute as members who are entitled to vote at the meeting. So this homework has to be done very, very diligently. Related party aspects. Related party aspects are very important first for the unlisted companies and for the listed companies. The LODR provisions are separately to be checked. The revised SS-2 has now put up this particular provision in a way that a member who happens to be a related party in a resolution relating to approval of any contract or arrangement in which he or she might be interested as a related party is not entitled to vote, except now there is an exception, that where 90% or more members in number are relatives of promoters or are related parties already. So this exception is provided. And in case of wholly owned subsidiary also, if the resolutions have been passed by the holding company, that would be sufficient. That would suffice for entering into the transactions between the holding company and the wholly owned subsidiary. Now, in case of private companies and prescribed categories of government companies, the related parties can vote. Right? Then the chairman has a second or casting vote. But if the articles provide otherwise, then this second vote, casting vote is not available to the chairman.
One thing is very, very clear here. We are discussing the master clause on the company side. So we are concentrating most of the things on the company side. But when it comes to the listed companies, the listing agreement LODR regulation applicability will have to be separately checked when it comes to related party voting, etc. and all these things. So LODR regulation will prevail because company has to comply with both the provisions of their act, LODR regulation as well as company side. Yeah.
Yes. Yes.
For example, I'll add here.
Yeah.
For example, I'll add here, like a related party, In SS2, it is the member who is interested. But in LODR, it is the whole group of promoters. If anybody is interested singly, but he pertains to a group of promoters or the persons acting in concern, neither of them can vote in favor of the resolution. They can vote against, but they cannot. Entire group is taken into account.
You are
Right,
very
ma'am.
right, Mr.
Please.
Bhatia sir. That is why I said, because LODR regulation separately to
Ought
be
to be
checked for
read.
the listed companies, and it has to be complied with whatever it is. Yeah.
Very right. Very right, sir.
Yes, yes. So for the conduct of e-voting, there is this long drawn process which has been very, very aptly described in the guidance note. So I have taken some relevant portions from there. Board approval is very critical. The requirements for conducting the e-voting, what do you require? You need to appoint the scrutinizers. Who could be a scrutinizer? And whether the prior consent has been taken, and then appointing the agency for supervising the electronic platform, deciding the cutoff date, and authorizing the chairman or any director to receive the scrutinizer's report and other related papers, submission of report by the scrutinizer within 3 days, and the chairman will countersign the scrutinizer's report. Then how the notice will be issued in such cases. A 21 days notice has been prescribed, advertisement in 2 newspapers. So this entire procedure, then how the results of the e-voting will be displayed. They have to be displayed through all possible modes. If you have a separate head office or a corporate office other than your registered office, and also it has to be put up on your website. So the idea is that as many members who want to look at the results, want to have the information, so each place which is accessible to them, they can have a view. And similarly, listed companies will forward the results to the stock exchanges. So now here, can you withdraw a resolution or can you rescind a resolution? Here, there are some key terms which have been prescribed by SS-2. Any resolution proposed which is likely to affect the market price of securities shall not be withdrawn once notice has been issued. I have given an example. Issue of bonus shares. It could be right shares also, or if you're doing a buyback. This is important information which can influence the decision of an investor. And hence, if you're allowed to withdraw such a resolution, the adverse effect is obvious. It's not allowed. Similarly, in case of remote e-voting facility, once notice is issued, you cannot. It has gone. Now it will be put up to. It has been put up for voting, so you cannot withdraw. In case of rescindment, so yes, that is allowed. However, you have to make a proper disclosure by passing the fresh resolution in the subsequent meeting, even when you are drafting the minutes. So in the minutes of the subsequent meeting, the reference of the original resolution passed in the previous meeting has to be there. Yeah, it has to be interlinked so that complete reference is there for all times, that which resolution was passed earlier and which has now been uh, rescinded. So Bhatia ji, can you take over for a minute? I need to get my charger. Bhatia ji?
Zibulji, I have
Hi.
already earlier taken up this matter that resolution proposed once in the general meeting, either in the AGM or in the EGM or in by postal ballot, cannot be withdrawn, modified. It is only can be either modified by subsequent resolution or rescinded, even as you have rightly said, by passing a resolution, a separate resolution in the same manner in which the earlier resolution was passed at a subsequent meeting, either physical or e-voting or by postal ballot.
Yes.
Right?
Yeah, so these are important provisions. Another one is for modification. Yeah. So this can be linked to what we discussed earlier, that regarding the grammatical
No.
errors and issuing corrigendums and all.
No
Whether
modification.
modification to resolutions is allowed.
Not allowed.
Not allowed.
Not
Not
allowed.
allowed, but
Even, let me tell you that in the why I'm saying not allowed is in the e-voting era. But in the earlier regime of physical meetings, we right to pass a resolution with or without modifications. There we give a chance that there is a procedure how to modify it, that a person will move a resolution for modification, and modification will then be put to vote, and then the resolution will be modified, and then it will be put to vote again. Then the modification is only not, as Mr. Balaji has rightly said, not a material one, it should be a clerical one or something minimum. Then that is allowed. Then that is the prerogative of the chairman, how much is to be allowed. But now, as when the e-voting is there, it is not mentioned even in the notice. To give your assent or dissent, it is only mentioned. No question of modifying. It cannot be modified in electronic form.
so the words, they have become so sacrosanct, with or without modification.
It is
So,
not now there in the e-voting criteria. Na? Here we write only to give your assent or dissent to the following resolution by way of SR or OR. Earlier we write in the physical that to pass the following resolution with or without modifications as an ordinary resolution or as a special resolution. But now that as a with or without modification contents are not there in the notice in the electronic form.
True.
It cannot be moved. Modification cannot be moved in electronic form.
So
There is
reading
no
of
provision in the
reports,
system.
yeah, true, agree. And reading of reports is again the qualifications, observations, adverse remarks in auditor's report, secretarial audit report. They have to be read at the meeting. And now we come to this part, distribution of gifts, whether it is allowed, not allowed. I have included a case law here, a very relevant one. Again, thank you, Bala sir, for your wisdom here. It's a very interesting one. If I'm not wrong, you mentioned this as a speaking order, right, Bala sir?
Correct.
So see, in Madras Fertilizers Limited, there is a violation. There is a distribution of gifts in the AGM. The ROC Chennai passes an order against the company and directors, levying a penalty. But on appeal, the regional director Chennai says that the action can be initiated only against the company secretary, as he, being the compliance officer, is responsible to ensure compliance under SS-2. And this is dated 29th November 2022. So what kind of gifts? Cash? No, it's not allowed. It's discriminatory. However, as a courtesy, any refreshment, packed food at the venue of the meeting, that is permissible. Or any discount coupons relating to your products or services. This is also normally.
As for SS-2, no. SS-2 specifically covers that no gifts allowed.
Yeah, no gifts allowed. The guidance note mentions that
only
courtesy or serving of snacks at the venue.
Yeah. Serving of snacks is not an
tea,
issue.
coffee, snacks is okay, but no gift, no discount coupon, etc. But however, one exception is there. If the company is offering a discount coupons on their products, that is permitted actually. For example, if a company is dealing in the cloth business, if they are allowing a discount coupon on the cloth business of the purchases, that is allowed. But if they decide to give the discount coupon on Amazon purchases, that is not allowed.
So, sir, no. So, if you have a company like Raymond's, they give invariably those coupons. Like
Raymond is the one which is actually distributing the coupon for their product. That is permitted.
Which is permitted, okay.
Yeah, but on the contrary, the Raymond decide to give, I will give the discount coupon on Amazon product. That is not permitted.
And there is one more important
the company's own product, if they are giving a discount coupon, that is permitted.
Okay, so if I'm a shareholders of this East India Hotel, EIA,
Yeah.
There also, no, they say, look, if you're a shareholders, you'll get some 15% discounts on our hotel rates.
Yeah, that will be well within the limit.
That is okay.
allowed. Yeah, that is
Okay. If I'm a shareholders of a Mahindra Holidays,
Yes.
so they say, look, our membership is 5 lakhs, and you being a shareholders, will give you at 4,50,000. That is also allowed.
Yeah, their own product. Any discount allowed, the product, the services which they are rendering, that is permitted. But other than that, everything will obtain the color of the gift, that is not allowed. Yeah,
And
as you
that-
rightly said, Raman is the one who has been distributing the discount coupon for their cloth for years together.
Yes. And one
Yeah,
important aspect is that this has to be provided to all members.
All, not
attending,
selectively.
whether
Yeah.
they are, even if they're not attending,
Yeah,
then
there
also
cannot-
it will be considered
Yeah.
as discriminatory.
It cannot be discriminatory.
Yeah, yes.
Equality.
Yeah, so if I'm a shareholders of a Nykaa, they have a lot of things online. So, Mr. Bhatia, what is your view? Means, these are all allowed, right? Means, unless and until you are giving some
I
special
am
favor.
100% with Balaji. Companies own products in whatever way they are promote. This is a promotion of the company's product at a gathering, not a gift. It can be taken up like that only. But if you are giving anything else, that is not allowed. Your own products, you are giving discounts, you are giving samples, that is allowed.
Then adjournment of meetings, how you can adjourn. Otherwise, meetings, a duly convened meeting shall not be adjourned unless the circumstances so warrant. The circumstances are like you can adjourn with the consent of the members at which a quorum is present in the event of disorder or similar causes, and where if it is directed by the members. So a poll may be demanded on adjournment, and if the poll is taken, the poll has to be taken forthwith, the meeting can be adjourned. But if the quorum itself is not present, for want of requisite quorum, the meeting automatically stands adjourned. So there are basis the time period of adjournment. The SS-2 says that how you will give a notice of the adjourned meeting, right? So if it's like for indefinite period or less than 30 days, so accordingly notices will be given. And if at the adjourned meeting the quorum is not present within half an hour, then the members present not less than 2 will constitute the quorum. And in case the meeting is called by the requisitionists, then if the quorum is not present, the meeting stands cancelled. And only the unfinished business of the original meeting can be taken up at an adjourned meeting. Now, as we looked at the procedures for conduct of e-voting, there is a procedure for conduct of postal ballot also, which is prescribed by SS-2, right? So here the threshold is for members above 200, which have to put the resolutions for voting by means of postal ballot, and only the prescribed items of businesses. This is underscored. Now there is a list. I think there are around 11 such items where you have to where these items of businesses can be transacted only by means of a postal ballot. Ordinary business cannot be transacted as such. So similar to e-voting procedure, first of all, the board approval is required. Identifying the businesses, notice, then authorizing the company secretaries or director to conduct the process, appointing scrutinizers, prior consents, appointing the agency, deciding the record date, and all of this board approval is taken. And then how the notice has to be given, accompanied with the postal ballot form and specifying all the material facts, availability of e-voting facility. All of this has to be mentioned in the postal ballot form, and a postage prepaid reply envelope has to accompany. Clear instructions have to be provided, and otherwise the form will be considered invalid if it is not properly signed or the signature does not match, dissent is not properly coming out. So all these aspects are important it's very important clear instructions are given, because then see the whole process fails. The whole process fails. You have done your bit, but then people, the members across, they fail to understand how to put the votes, how to properly sign, how to convey their assent or dissent, and then the voting fails. So clear instructions is important.
So those who wanted to ask a question, they can raise the hand also. We'll allow them, after the discussions. So we'll ask them to speak also. Yeah. So Rakesh Pandey has raised the hand, so definitely we'll allow you, sir. Yeah, Amrut will continue.
Yeah, let us finish up this.
Creative, I can say, I'm just quickly finishing some creative question. I just saw that what happens in case of misplacement of recorded meeting video file. So,
No, let
how
us
can you
discuss this.
misplace
You
it?
finish up this thing because we are close
Yeah.
to the time. Because it's already 12:45.
So,
Yeah.
then minutes of meetings, minutes, the usual provisions relating to maintenance of minutes. Every company should keep the minutes, distinct minute book for different categories of general meetings. They cannot be combined together. The resolutions passed by postal ballot, which has been done separately, has to be recorded in the minutes books also before they are closed and signed. And we have been addressing in various webinars. I have addressed once. Sudhakarji, I think I remember he has addressed 3-4 times the same query if someone wants to ask that how minutes have to be maintained in electronic form, physical form. Yeah, we have had ample discussions earlier. Time stamping, secured computer systems, everything fails if you are maintaining Excel sheets as your record of minutes, but if it is not through a secured computer system.
Correct.
Right?
Just typing at the Word file or putting in a PDF file or putting in Excel format is not the electronic record.
Yeah, no.
All your records, instead of maintaining in its physical form, is required to be maintained electronically, means in the computer with the due date timestamp. Then only it is an electronic form. You can't selectively maintain one document in electronic form, other document in a physical form. That cannot be the case. Either you choose either physical or electronic. That is the way it has to be done.
Yes. So
And
minutes and
another thing is that I would like to also
Hmm.
raise my concern when you are talking about the minutes. It is mostly happening with the private companies, unlisted companies, and more so in the companies where the company secretaries are not there. There are various trivial issues on the minutes. It is not numbered, each page is not signed, a large page is not dated, chairman's full signature is not there, numbering of the different meeting is not there. All these sort of the very trivial issues on this issues are there. There have been left and right, ROC is taking up the matter, etc. But
and even blanks in pages, because the printing is not happening properly.
but my due concern, whatever you say, ultimately, we professionally, either in the practice or in employment, we are responsible for compliances. And okay, the company where practicing company secretaries are rendering the service, okay, at least they should give them proper guidance to the people who are there so that they can maintain. If the directors are there, they are authorized some person, to tell, look here, this is what it is, this is a requirement, provide a checklist, those things is there. Periodically, when you go there, you also have a look at it, check them. That is how the compliance can be brought in. Otherwise, simply, doing the job and what is assigned to us, I had done the job, that's enough. That is the thing. All the things will get continued. We have to raise our bar and go beyond what is, called for. We normally talk, what we call customer delight. That is the level we have to reach. Especially those companies where the company secretaries are not there when practicing people are rendering the service. Yeah.
Yes. And then content of the minutes, there are general contents at the beginning, how you put up the serial numbers and the meeting details, the time of commencement, conclusion, and the names of directors
that is why our
in
SS,
alphabetical.
that is why our SS is actually telling the way of writing the minutes, what is the thing, everything in detail. Even SS1 talks about it, SS2 talks about it.
Yeah. Specific content, again, I'm not reading out. A lot of information is there in the guidance notes. None of this can be missed. So my presentation has to include and mention all these points. If you are missing on any of these, please check. Please, this is all important mandatory information which should form part of your minutes. How the minutes have to be recorded, a fair and correct summary. The chairman has the discretion to exclude from minutes in situations where he feels that it might be defamatory to any person or is immaterial or detrimental to the interest of the company. Clear, concise, plain language, and each item has to be numbered. Then entries within 30 days in minutes, signed and dated by the chairman within 30 days. Uh, uh, in the event of what will you do if the chairman of the meeting is not able to sign, is unable to sign the minutes? I have also witnessed one of the honorable chairman, a distinguished dignitary in the country who left for the heavenly abode. So how? So I don't know how many of you know the solution. That time we also thought about it, but then a resolution has to be passed by circulation so that some other director is authorized to sign the minutes, but the 30 days period cannot be breached. It has to be entered, signed within 30 days from the date of conclusion of the meeting. Inspection, directors, members can inspect, but only members can take copies. Now here, minutes have to be preserved permanently in physical or electronic, whatever you're maintaining. It's a permanent record. And however, the other accompanying documents, the notice, for that, it's 8 years timeline is there. And safe custody of the company secretary. So company secretaries, you are the ones responsible for all these compliances as well. Safe custody comes with ensuring compliance only. And then there is a report on AGM, which has to be submitted, prepared by the listed entities. And it is in addition to your minutes. And in Form MGT 15, it has to be submitted and filed within 30 days of conclusion. And there are some aspects, some information which you are supposed to disclose. That information has to be disclosed. In annual return, you make disclosures, right, at the end of the year. Now, this is the last critical segment of our presentation today. Bhatia sir. So instead of reading, we all, I'll just quickly, because this is my compilation, that I wanted to point out that in the Companies Act, there are no specific provisions for conducting meetings through VC or audiovisual means. Yes, there are provisions for e-voting, electronic postal ballot. In fact, in some other provision, there is this prohibition that the approval of financial statements, board report can only be done in a physical meeting. That was the reason why at the onset of the pandemic, this decision was taken by the Ministry of Corporate Affairs that general meetings through VC or audiovisual means will be allowed. So there are requirements. I have only touched upon some few relevant for those companies which are providing the facility of e-voting, and those companies which are not providing the facility of e-voting, how the voting will be done in AGM or an EGM through VC, which we are doing since 2020. Every year, the general circular of 2020, it has been, the provision has been extended to 2022, 23. The latest position is the circular of 2020, September 2023, where the current set for the current year also, this facility has been extended, and the companies are allowed to conduct their general meetings through VC on or before 30th September 2024. So, Bhatia sir, to end up this conversation, this presentation, I would rather, request you to uh, to make the participants understand and go through the real-time procedure that is being followed nowadays for these meetings through VC. Some relevant aspects.
Well, Mridulji, first I would like to thank you for a nice presentation, elaborate discussions, and the insight into the all provisions pertaining to the calling, convening, holding, recording of minutes, etc., of journal meetings and postal ballot. Though we all are aware, but for freshening up our knowledge, you had given us an really good break into the things which wakes up our knowledge where we were silent so far. As far as the conduct of uh, journal meetings or the postal ballot through electronic media. Well, as you have rightly said that the notifications are there through which this facility was extended in the pandemic zone, and with the recent circular, this is up to 30th September 24 only. No further circular has so far come. So all companies can conduct their meeting through electronic mode through VC audio video means, and they have to follow certain guidelines as prescribed in the circular. Now the question, as you have rightly touched, that there is no provision in the Act. No provision in the Act, neither there is any provision in the Articles of Association of the company. Yet, Ministry has given us leverage to overrule the Act as well as the Articles of Association of the company and to do this procedure through audio video means. For this only, we have to go with the same route that the board meeting is to be called, then the board meeting will approve the notice calling convening of the general meeting, and scrutinizer will be appointed, agency will be appointed. By agency, we mean NSDL, CDSL, through which platform we will conduct. These days, we have private players also beside NSDSL like Carvi. Carvi is giving us this facility. LinkedIn Time is giving this facility. So that depends upon the company to choose the platform. But my experience is that the government agencies, particularly NSDL, is giving us very good service in this regard. First, from dispatch of notice to scrutinizing report, preparation of scrutinizer report. A. The process is A. Remote e-voting, as you have rightly said in the contents that we have to mention in the notice, the entire procedure of e-voting. It is, I would like all the professionals to go with the NSDL or CDSL and get them checked all the procedure, or they provide us a copy that what to write in the notice, how this procedure will be formalized, how the button will be on, how they have to click on the button, how they have to select, particularly those who become members after the cutoff date, before the cutoff date, and the entire procedure. Then remote e-voting is in the case of postal ballot, it is throughout for the 30 days period from the day it is open till the end of the day. But in the case of AGM or EGM, you have rightly mentioned in the slide, one of the slides that at least minimum as per SS-2, 3 days period is to be given. But that is the minimum period. Companies are free to give more than that, 4 days, 5 days, or whatever way they are feel comfortable to give voting period to each and every member to cast their vote for and against. Then on a day before the date of the AGM, the voting closes through remote e-voting. Now the process is e-voting at the time of AGM. If the AGM is being conducted through VC or other audio-visual means, then electronic media is taken. Same agency will help you out. There, we as a company secretary has to announce that all the members, those who have not voted through remote voting, can cast their vote now. That the procedure is explained in the notice itself, and the button is there in the screen. You have to click after the proceedings are over. Then this voting will remain open. Right to vote will remain open minimum for 15 minutes and maximum 30 minutes. Then we keep it open that to give facility to all those who have not voted. they will now cast their votes. After half an hour, when that time is over, we request we as scrutinizer close the voting at NSDL or CDSL or Carvi counter. Then the voting is closed. After that, the agency will process all the data and will provide us the details about the details of the votes cast in favor, vote cast against, invalid votes. Now, here the one more important thing is that, like in physical meeting, we get resolutions for the professionals who attend on behalf of the corporate bodies under Section 113. Here, there is no specific instance where we can physically check it. But in the notice of the general meeting, annual general meeting, postal ballot, etc., we invariably write that the resolutions under Section 113 giving authorization to cast vote should be given well in advance before the close of the voting to the agency as well as to the scrutinizer. And we do invariably get the resolutions from the authorized in favor of the authorized person by the corporate bodies, etc. Then, after we get the result, normally we match it that the from the attendance, those who have voted, we filter it and see the companies, listed companies, or the others, those who have voted, that they have provided their 113 resolutions. So that is the exercise we have to do for matching it. And then on the basis of the data provided by the agency, we as scrutinizer prepare a report on the based on the information given by NSDL CDSL. I'll request all my professional friends that as far as the listed companies are concerned, we have to file XBRL in under as per regulation 44. For that reason, if you well in advance tell to the agency, they give you the filtered data for that reason also that you can make your XBRL report. That way, NSDL services are very good. They give you a complete process data so that you can prepare your XBRL data in the format given by the stock exchanges and put it. Otherwise, it takes little time to scrutinize and the entire voters list, make out that who are the promoters, who are the public financial institutions, who are the non-resident, and then to make out the XBRL data. Then, based on the scrutinizer report, we see it whether resolution is passed with requisite majority. And before that, we, as you have rightly said in one of your slides, that in RPTs, those who cannot vote, we see that they have voted or not voted. So for that reason, we physically check also taking the data from the concerned company, as well as we take an undertaking from the company as you can say an MRL, management representation letter, that those who are interested in the resolution, all the RPTs, whether they are the promoter, directors, or KMPs, they have not voted in favor of the resolution. And then based on that, we also put up a note on in that particular item that while making out the report on this item, care has been taken that all the RPTs has not, their vote has not been taken into account. Right. So based on our report, we submit our report to the chairman or to the person authorized by chairperson in this regard. Normally, you have written that in the SS-2, the 3 days period is there, but in the listed company's case, as per LODR, it is 2 days, 48 hours. So we have to submit our report within 48 hours. We submit our report to the chairman oblique to the authorized person. Then, as per SS-2 and as per the regulation 20 of the rules, that the chairman has to declare the result on the postal ballot or on the items of the AGM, EGM. That result is then posted on the company's website, given to the agencies as well as to the BSC and NSC, wherever the companies are listed. While giving the result, we have to take care that the contents of the SS-2 are elaborately covered in the results, declaration of result, post giving of scrutinizer report to the AGM, to the chairman. This result should be declared as far as law is concerned immediately on receipt it is written. So as early as possible, the chairman is to declare the result and declare that all items have been passed or not, if passed with requisite majority, and all the contents are to be covered in that. So with that, after that, the listed companies have to come out with another reports to the stock exchanges, submission of the scrutinizer report and filing of XBRLs, etc., and the outcome of the board journal meeting within half an hour. So this is in short the procedure is. Anybody has any query? I am ready to answer. Thank you, ma'am.
Thank you. Thank you. Yes, you have very
Mridul,
succinctly.
we have a Mr. Ajay Tiwari standing for a very long time. Mr. Ajay, you are there?
Good
Yeah.
afternoon, sir. Good afternoon, ma'am. Thank you for a very insightful, session, and I am sure it will keep all of us on toes. There are a lot of requirements, nitty-gritty and detail. So, okay, I have just one query. I read somewhere in this presentation, ma'am, that company secretary need to be seated beside chairman during the meeting. In this era of VC, is it not possible chairman can be at different location and CS can be different location? This is the only question which I have. Just can you clarify?
So yeah, sure. Why not? Not only this, there are so many provisions. If you look now, because see, our aim today was to look at the provisions of SS-2. And SS-2 was drafted when there were no provisions for holding general AGMs through these VCs and virtual meetings. So it's fine, but here common sensically, yes, you're right. How is it possible? Now the virtually you are attending meeting from some other place. The company secretary is sitting, might be in office somewhere. The chairman is somewhere else. Seating and all is not relevant. So we need, it's purely common sense here, and you have rightly pointed it out.
Not only that, in the VC meeting, again, the question arises, what is the venue of the meeting? Where the chairman is sitting, whether that is the venue, or the company secretary sitting in the registrar office, that is the venue.
From where the recording is.
Yeah.
So we will be attending from the registered office. Then I think it will be deemed to be a place of office. It is clearly written in one of the rules that place where meeting recording is done, that will be place of meeting, deemed to be.
Yeah, you are absolutely right. So the question, as you raised it, if the chairman is attending elsewhere, the sitting company secretary next to the chairman and all this thing will not be relevant in case of the VC meeting.
Thank you, ma'am. Thank you, sir.
Yeah, Mr. Amit Kundu, you wanted to.
We have some more questions actually here in the chat box.
Okay, sir. Those who have raised the hand, we will take them first. Yeah. Amit Kundu, you are there? You can unmute yourself first. Amit, you are there? Unmute yourself first. Okay, I think he's not there. So PSR Murthy, you are there? You can unmute yourself first.
Good afternoon. Sir, the question is like this. What I raised is that there is no board in place in the sense that is there were only 3 directors in the government company this is related to, and one of the director is not accessible. So therefore, there is no board in place. Section 96 is an independent section as compared to the any other thing. Then in that case, in case the board authority is prerequisite for AGM, then simultaneously we will be committing violation with section 96 also. So why not we do like this, convene the AGM as such, that one, and get it ratified when the board is formed.
I think you need a detailed discussion. You can call a separate. Yeah, Mr. Bhatia wanted to give answer.
Shortly, I will cover it. Whose authority? Who is the authority to convene the meeting? It is the board of director. When the board is not in place, no question of anything else. Right? It is default by the board. It is default by the company. It is the owner's under duty of the board. So, as you, my dear friend, has said that we can call the meeting and then ratify it. There is no question of ratification. Onus is on the board.
Right.
In the case of government companies, you can approach the central government.
Yeah, that's.
You have to approach the concerned ministry in that case, because there seems to be a deadlock. Because government company, they have the separate rules. In fact, many of the company secretaries who used to work with the company secretaries, they used to call themselves, they are like a situation like Draupadi having 5 husbands. There's owner, somewhere you let to report to the company, somewhere to the
And,
secretary, somewhere to the administrative officer, somewhere to the parliament, all those things.
And Mr. Murthy, there is especially it's mentioned in the SS-2 that not only the authority of the board, but also that the board has to be duly constituted. This is a precondition.
Yeah.
Precondition. It's a precondition.
Precondition. Yes, there is a specific provision. Yeah.
Yeah, Amit, you are there. You can, yeah, Mr. Amit, we can now take your questions. Amit, you are there? Amit Kundu, unmute yourself.
Can
Yeah.
you hear me?
Yes, now we can hear you.
Good afternoon, sir. It's a nice presentation.
Yeah.
I just want two clarification. Need two clarification. One is relating to the Section 8 company and then related to any company. Now, Section 8 company, what I saw in the presentation, the AGM can be called less than 21 days meeting, even in 14 days notice, that can be done. Am I right?
Provided provision is there in the articles.
Yeah, you are right. But only thing is article should have the provision.
Ajay, next is question is physical voting. Like electronic voting, you say a minimum 3 days. Electronic voting generally a company allows before the AGM 2 days or 3 days. Physical voting other than AGM, is it allowed before the AGM days?
Sir, what is the question of physical voting before the
Physical
meeting? Question does
voting,
not rise. It is only voting at the
you-
time of meeting.
You have to
It
think
is
in terms of
voting can be
postal
done
ballot.
only at the meeting.
Yeah,
No prior.
When you talk about the physical voting takes place only at the meeting, na?
At the
Correct.
meeting.
Correct. So that is the confusion is there in some of the Section 8 companies. They are holding the physical voting before the AGM day, maybe 1 or 2 days. So in my opinion, it is not valid as per the law. So I just
Very
want
right.
to clarify whether I am right or wrong.
You are
Very right,
absolutely,
sir.
you are absolutely correct. Physical voting means voting done only during the annual general meeting. At the venue when the meeting is actually there.
And sir, the third one, this EGM, if we have to call, like here, 20% of the voting right is required for calling of EGM. Now for the Section 8 company, 20% means a huge, because there is no sort of voting right who controls a 10%, 12%. So suppose if there is 1,000 member in Section 8 company, so you 20% means 200 people will have to sign or have to call for that EGM. So is it also valid for 20%, or is it if the article says 10% is allowed to call for the EGM, which one will prevail? The article 10% or the act is 20%? Because though act is a mother, article is a byproduct of the act. So in my opinion, act to be followed. But in case of this, in the articles, will it be followed?
Mr. Amit, what I'm requesting, you have a Mridul's number on our website. Probably you can call her, separately. I think, we have just exited our time. So,
Okay.
Mr. Bala, can you just propose a vote
one
of
thing
thanks,
is very
please?
clear. One thing is very clear. Article cannot override the act.
Correct.
Article can actually provide more stringent provision than the act what is permitted, but article cannot provide lesser than what is there in the act. So article cannot override the act.
And that is why it is mentioned for Section 8 companies that even if they are exempted to comply with certain provisions of SS-2, but they have to still comply with the provisions under the Companies Act relating to general meetings.
Yeah, that is right.
And then you have a prerogative, but as to have some provisions in your articles, but they cannot overrule the provisions of the Act. They have to be stricter rather. Yeah.
We are already 115. We are already 115. Let us look at the questions very quickly. What is the time limit to keep the recording of the board meeting of the board meeting of or AGM?
AGM proceedings.
Recording will be recorded till the such time your auditing and other things, certification, filing is everything is done. It will be recorded because this will be called by the auditors. So that will be required to be produced. Probably, practically speaking, the time the practical where major numbers are residing. Oh, this is not relevant as far as today is concerned, because when you can conduct the meeting anywhere and everywhere, which is permitted by the law. How to conduct the AGM in case of the grip?
Bala sir, before that, one more query relating to this. That this is interesting. What if the video recording gets misplaced? Someone is asking. So,
see, the video recording is misplaced is the problem, but the thing is that the law permits only in case of the technical problem, something did not get recorded, etc. You justify and give it. That is what will happen. Misplaced, I really do not know how to answer that.
So it's a compliance lapse, according to me. It's a compliance lapse, and it's a lapse under the Data Protection Act also, the Information Technology Act also. Because then, and there are stricter penalties. Why I'm raising this question? Because I really like this question. Now, this is a big compliance lapse. Check your IT provisions. Then
it cannot be. Company secretary cannot afford to go so careless, because we also used to conduct the video recording. Immediately after the recording is over, I used to collect it and put it in the lock and key in safe custody. If a company have 40 members and only 5 members came to attend the meeting, having 15% shareholding, in this case, can they pass special resolution in that meeting?
How is it possible?
Why not, sir?
How many members? How many members in number?
5 members. Quorum, if the quorum is complete as per law.
Only thing is, in this case, if the quorum is complete, if the members present majority, they vote, it is all right. But only thing is, the company has certain number of specific shareholding also attached to that, then that has to be looked into specifically.
So if the voting rights are attached, so that is what I'm seeing. So otherwise, it's fine as far as the number is concerned and the total quorum which is present. But if there are voting rights,
article is to be checked out. Voting right is to be, percentage of holding is mentioned, then that will be a problem.
Yes.
Section 168(3) may be guiding subsection. If the person who write the query means that there is a no board, this I think we discussed enough. In the case of the private company, if the accounts are not ready in the AGM, can we still conduct the AGM? If the accounts are ready only after 6 months, what needs to be done? The huge penalty. This is there. Because not having the accounts is not the rescue, but you need not have the account, but you can have the adjournment. But within the time, if you don't conduct it, you end up in the penalty. That's all. This is a simple non-compliance. Okay.
Adjourned meeting cannot be held after the expiry of maximum time period.
No. Addendum we have discussed actually. If something is missed out and we related the matters and been done, is issue the new correct AGM notice. Would ROC allows extension of the time in this record? What is that? If something is missed out and we realize that the mistake has been done, so to issue the new corrected AGM notice, should ROC allow extension of the time on this ground? Much will depend upon whatever the case is there, because without doing the thing, we will not be able to answer. But the justifiable reason ROC will allow, much will depend upon what is the case and circumstances. Retiring director or who earlier expressed the willingness to be reappointed, later on resigned when the notice was already sent. The listed company, it has happened, the company sent a notice to the shareholders electronically that the resolution of his appointment need not be voted. Is this example when notice was already amended to that effect? Somebody is sharing this. Could you share the PPT? PPT normally we do not share because the recorded webinar is actually disseminated to the people. You can access which contain the PPT. Section 160 permits to a member to send the notice of appointment to the director before 14 days of AGM. I do not know this is relevant to what. Do we need to file a copy of the notice of AGM while filing the annual report?
there are annual forms, filings, and the attachments have been prescribed specifically. So we follow those rules. Whichever attachment is provided, file it accordingly.
If the adjourned AGM is held after the expiry of the maximum time holding, what is the consequence? Fine and penalty. You face the consequences.
Yeah, I
Default
covered
under
this.
Act.
Adjourned also within time limit.
Yeah.
It is a default under Act.
Yeah, that is right.
Yes.
If
So
the
we discussed.
If the annual return of the company where the AGM is adjourned, which should be mentioned the date of the AGM or original date of the AGM when adjourned meeting are held. Adjourned meeting is as good as the original date of the meeting.
This one question by Mr. Rakesh is, it's a good question.
Yeah.
What happens when neither the auditor or representative could attend the meeting? How exemption is granted? So, dear colleague, exemption you have to seek prior, not that you didn't come on the day of the meeting and then later you are asking for exemption. No.
The auditor
exemption
generally seeks
has
the
to
exemption
be-
the company grants, and even it gets recorded in the minutes saying that
Yeah.
the auditor is actually unable to attend and he sought the exemption for not attending the meeting. The company is granted. That is the way it is actually done. Yeah.
It is prior to the meeting, not after the meeting.
Mr. Bala, every good thing has to come to an end. So let's conclude this.
Okay.
We can take up those sessions, and we have gone beyond our time, and our faculty also probably, has
Okay. Sure.
cooperated us. So
Okay.
please, we can propose a vote of thanks.
Sure.
Yeah, Mr. Bala, you can propose a vote of thanks.
I think, Mridul, you can close the presentation.
Yes, sir. Done.
Thanks a lot to Mr. Bhatia, because in fact, your practical experience, especially sharing with the NCLT permission, sharing with the VC things very elaborately, has really given a lot of things. In fact, personally, I have learned a lot of things today because I am actually out of touch. I am actually in touch with what you call theoretically, not practically. So your practical wisdom has added lot of things what is actually happening in keeping time with us. That is one thing I am personally very much thankful. The same thing will be with the other people also. Coming to Mridul, she has extensively done a very good homework, touching upon all the aspects right from the beginning till the end, what is actually covered, including the latest amendment which has actually come out. Even she has incorporated lot of things from the guidance note which is issued. As I said in the beginning, I request everybody kindly go through the latest SS-2 amended one along with the guidance note so that we can avoid. Because somebody raised what it happened, this happened. Lot of practical examples have been given. Mr. Bhatia would agree. They would be spending, they'll be burning the bitter oil in bringing out these sort of things, spending time in a SSB board. So much expertise, so much knowledge which actually goes in bringing out things. Even Atul Mehta was also there. So definitely they all will know how much expertise which actually goes. We should make use of it. Thank you very much, Mr. Bhatia. Once again, hats off to you. Thanks a lot. My appreciation to Mridul. With this, we close the session. Atul, as usual, thank you very much for organizing.
So thank you, Mr. Bhatia. Once again, and nice to connect you after so many years. I'll meet you somewhere whenever I'm there in Delhi, sir. Or if you are anytime.
I am in Delhi, so I'll meet you first.
Oh yes, you should. Thank you, Mr.
Bhatia. Actually, I am thankful to Mr. Mehta ji. When I got call this time, I thought, let me really take this opportunity, because earlier also you called me some time back, but then I was stuck up somewhere and couldn't join you. But this time I thought that let me have a part. Thanks for giving me this opportunity, and thanks for Mridul and Balaji for their entire cooperation. And excuse me for my mistakes, and thank you very much.
So all of you are requested, you can, in case if you missed out any of our webinars, you can just log into YouTube channel and you can subscribe to that so that you are not missing out anything, any of those, So go to the YouTube Decoding Company Law with, Mehta and Mehta, something like this. So thank you once again. Thanks, Mridul, for your wonderful presentations. Thank Akshar and the team Mehta and Mehta. Thank you. Thank you, sir. Bye-bye.
Thank you. Have a good weekend.
Yeah.
We will yet to meet in the next week.